not that I haven't finished, and I confirm that I have.
Yes.
In answer to my Lord Justice Arnold's question about pensions,
Oh, yes.
there are two, in the supplemental bundle at 93, my client's maintenance pending suit effectively statement, he refers to monthly income from a Morgan Stanley and a Deutsche Bank pension, totaling about £1,100 a month, and then 365. He specifically asked questions by a known friend, starting at between A and B in 365 transcript about pensions in payment and whether they would be subject to the jurisdiction of the court. I beg your pardon. He didn't dispute them. He didn't dispute they were subject to the jurisdiction of this court.
Okay.
But I only hesitate, my lord, because as a matter of fact, I don't think minds have been applied to that question. My own friend asked questions about it, and that's the only evidence we have in that.
Thank you very much. Yes, Mr. Buczowski.
My lords, you have our skeleton argument and our grounds for within the respondent's notice. The latter document, the respondent's notice, we commend to the court as being quite a useful nutshell summary of our primary case on the issue of domicile. And I will expand on those submissions briefly in a moment. The skeleton argument of 25 pages, I don't propose to repeat everything we've put in there, and these submissions are intended to be supplemental to those. Some issues clearly I'll deal with in more detail than others. My lords, as with the skeleton argument, I deal first with grounds 5 to 7 of the appeal, which I think both of us have termed the umbrella grounds. They're the criticisms of the judgment in the round rather than specific to the issues of domicile and forum. I intend to deal with these points relatively briefly orally, merely to really confirm and explain our position in the light of what Mr. Marshall said this morning. Specifically, I'll deal with 5 and 6, the deficiencies in the judgments within the context of domicile and forum, as I say. But in relation to the wider points, I just emphasise what we've already said in writing, which is that the consideration of the adequacy of any judgment is clearly context specific. And we in our skeleton argument make the point that what the judge was dealing with here were fundamentally routine and relatively simple issues. On the issue of domicile, there really only was one issue for him to determine, which is what was my client's subjective intention.
I'm sorry, how can you possibly say that when he also had to consider issues as to domicile of origin, whether there'd been a domicile choice in the first place?
There were 3 issues, yes, indeed, and he dealt with each of those.
You can't say there was only one issue when you straight away concede there were 3.
In terms of the issues that are now subject to this appeal, there was the one significant issue, which is that.
And do you say it's irrelevant that he had other issues to consider?
Well, clearly it is relevant because one looks at the judgment in the round, but they are not 3 totally different issues in the sense that the domicile issue, yes, there are 3 stages or 3 periods at which they have to be addressed, but the fundamental question which the judge was addressing in each of those was the same, question of intention. Except on origin, there was a slightly more nuanced assessment of the history of her family. But you see he deals with that in the judgment relatively briefly, and there's no appeal against the way that he has dealt with that. Just as there was very little evidence actually on the point before him. You would have seen in my client's statements, it's dealt with in a number of short paragraphs, and during the evidence itself, it didn't concern a particularly significant portion of the cross-examination or the evidence that she gave. The other issue was the issue of jurisdiction forum, which again is common fare for a judge of the family division. And there were no issues between the parties as to the law on the test that was being applied in either of those. Both of them, as your lordships are aware, are areas where the law is well established, and the same authorities were being cited by both parties and being referred to by both parties with the issue, as my learned friend correctly identified this morning, really being the application of those principles to the facts of this case, rather than any dispute as to what those principles were.
So in respect to domicile, the judge was invited to adopt, as he says in paragraph 7, what they just said in Barlow Close.
Yes.
And in respect of forum, the summary contained in paragraph 20 of His Honour Judge Hess's judgment of SA and FA.
Those are the authorities he's identified in his judgment, as I will in due course direct your lordships to. In our written note in opening for the hearing, as in oral submissions at the hearing itself, we also address his mind to a number of other authorities. One you've already heard reference to, which is Udney, and the other that's of significance is ILC and Bullock, which deals with many of the points that your lordship dealt with in the case of Kistramana, because indeed it was a fundamental authority within that case which the court adopted and applied as part of its reasoning. And as we'll see when I look at the judgment from Mr. Justice Garrido, you can see, although he doesn't specifically reference those cases, you can see from the statements that he makes and the conclusions he reaches that he clearly had those cases in mind. So, my lords, in terms of the English and Emery-Reinbold point in terms of clarification and amplification of the judgment, I am not asking this court to remit the matter now for the judge to provide fuller reasons. I accept that bird has flown. The stage at which that could have happened would have been at the point when Lord Justice Cobb granted permission to appeal as an alternative to granting permission at that stage. The point that we make is the point that we articulate really at paragraph 19 of our skeleton argument, which is that this remains a case where it was open and appropriate for Mr. Ferrara and his legal team to raise most, if not all, of the issues that they now raise by way of criticism of the judge's judgment with him, where they say there were deficiencies in his reasoning or gaps in his explanation as to how he reached conclusions.
How does that work? So the proposition is that they should have written to the judge to say, excuse me, judge, you haven't made any findings of fact on the matters in dispute. Please tear up your judgment or rewrite it. I mean, is that realistic?
My lords, the criticism, as I understand it, is fundamentally not that criticism. The criticism is that he has not adequately explained how he's got from certain points to a conclusion.
So the submission is it's a series of conclusions with no reasoning to support. But in particular, so far as domicile is concerned, there is a complaint of an absence of fact-finding in the light of a proper analysis of the evidence. Now, it's a separate question whether that complaint is made good or not. I mean, of course, your
Yes.
submission is going to be, well, there's nothing in it anyway.
Yes.
But at this stage, we're concerned with what they should have done. And is it really realistic to say, well, they should have invited the judge to rewrite his judgment? Because that particular domicile, I mean, in forum is perhaps a different question.
My lords, I accept that there's a matter of degree in this, and indeed the authority that was referred to this morning, the additional authority of INRI C, makes that point. If one is faced with a judgment where the judge has simply failed to explain at all what his conclusions are, then it would not be appropriate for there to be an invitation for him then to write judgment. That is, if you like, one extreme end of it. If you have a situation where the judge has given reasons, but you say you haven't explained why you've not considered or dealt with this argument that we considered was significant, or we don't understand your reasons for reaching this conclusion, that is a perfectly legitimate and indeed encouraged approach, and that is indeed what English and Emery-Reinbold recommends happens. So the point that we make at this stage is that if this court agrees that at least on some of the matters, even not on all of the matters that are raised by way of complaint now, that request should have been made of the judge, but was not. And now this court is being asked to consider an appeal on that basis. The court does need to be cautious in its approach to it. And that, of course, reflects all of the authorities with which this court, of course, is very well familiar, as to the reluctance that an appeal court will always show when it is seeking to interfere with a judge's primary conclusions on fact or the exercise of discretion, when they've had the advantage of hearing the totality of the evidence, which no court would ever expect them to recite in full.
Because you make the submission in any event that it's faulty and wrong, Page and Chobani, and we shouldn't do it.
Yes, it is in a sense a more expansive way of making the point that the court, in any event, will adopt in most cases, which is it gives the benefit of the doubt to the trial judge, unless it's clear that the trial judge has clearly failed to consider relevant factors or has clearly reached a decision on a flawed basis. My lords, before I move on to the specific points, there's just a couple of further general points, in fact probably just one, which is that actually on analysis of the evidence that was before the judge, and when you see the cross-examination that was before the judge, there were actually relatively few material disputes of fact, serious material disputes of fact between the parties. Certainly on the central factual issue as to what the wife's intentions were as regards to domicile, there was, as I'll explain in a little more detail as I develop my submissions, there was no evidence directly from Mr. Ferrara which directly challenged her evidence on those points. And I will refer you to the passages in the evidence in due course. But the key point is that he in terms accepted during the cross-examination of him that he didn't know what was in his wife's mind and that he couldn't gainsay what intentions she may have had. And bearing in mind the ultimate conclusion, the ultimate issue is one of her subjective state of mind, that is clearly significant. Well, just final point on the general points, and again, it's returning just to that authority that Mr. Marshall cited to you this morning, Re C. The only point, other point I make in relation to it, if you do consider it, is the context of that case was that there was a specific decision on a judgment made by a recorder in a case concerning care orders and an order for placement of a child for adoption in opposition, despite their parents' opposition to it. And as this court will no doubt be aware, there is a line of authorities that have arisen from this court referring to the fact that because that is such a draconian decision, there is perhaps a slightly more disciplined approach to decision making and the contents of a judgment that is required in those sorts of cases that is required across the board. And that's a return to my point about context. Well, I was turning to the issue of domicile and the judge's conclusions on that. If I may just very briefly deal with the law. My lords, as you've identified, the authority that the judge was cited, that he mentions explicitly is Barlow Close. We have had since then the decision in Kist Romana from this court. As I've already identified, he did have before him the decision of the Court of Appeal in IRC and Bullock, which, as I've already said, was a critical part of the reasoning in Kist Romana. So to the extent that Kist Romana has added some clarification of the law in relation to a loss of a domicile of choice, fundamentally the principles that he had in mind were the same principles, and I'll be able to show that he adopted those principles and applied them correctly in his decision. The one point that Romana Kist, I suppose, has clarified beyond the case law that we had when we were before Garrido, Mr. Justice Garrido, was as to the relevance of a contingency which has to arise before somebody can return to live in a domicile of choice. And although I don't think Mr. Marshall went as far before Mr. Justice Garrido to suggest it, the way he argued the case was almost on the basis that that contingency or that possibility of a return in the future was in some way a key part of the equation or even a threshold that had to be crossed. And as my Lord Justice Moylan made clear in Kist Romana, it is not. It is merely part of the full factual matrix which the court is considering. The fundamental issue remains and is always what was the subjective intention of the propositus at the relevant time. What we also know from the judgment in Kistramana is that where a judge concludes or a court finds that the intention was bona fide, it will require something compelling to suggest that that intention was not real. And that is something which in my submission in this case is fatal to the appeal that's been brought. My Lords, just briefly looking at Barlow Close and the judgment in that case, there is just, I think, one particular part that I would wish you to consider and highlight at this point, which is paragraphs 14 and 15 in the judgment in that case, which you'll find in the bundle of authorities. Forgive me. 77, I'm very grateful.
76 in hard copy.
On the printed copy, it'll be page 76, yes. My Lords, and this really is simply to highlight, to the extent it may be at all relevant, the point that Mr. Marshall was making earlier today, which is what the meaning or distinction between the words indefinitely and permanently may be. And the reason I highlight these passages is to make the point that this case, Barlow Close, along with all the other authorities that I think my learned friend relies on, AN and NO, amongst them, were cases where the primary issue before the court was the adoption of a domicile of choice. These were not cases where the issue was principally the loss of the domicile of choice. So although in Barlow Close the test is referred to, it's not actually what that case was specifically dealing with. But in the context of that, in my submission, these paragraphs are particularly helpful because the use of the term of an intention of permanent or indefinite residence works perfectly well when one is dealing with the acquisition of a domicile of choice, because we know the ingredients of that are, first of all, actual residence in that jurisdiction, then the intention at the time when that residence is existing. In the context of a loss of a domicile, as in facts such as these, the party has already moved to reside in another jurisdiction, and one is talking about an intention to reside in a country where they are not then residing. So to that extent, the passages that are referred to here, which refer to the well-known words from Bell and Kennedy of ending his days in that country, or the words of paragraph 15, to reference to ending one's days, usefully emphasises the need for the subject to have a fixed purpose that he will live in the country of his domicile of choice, are particularly apposite and helpful. And that really is the essence of the judge's decision in this case, because it's clear when we look through his reasoning that he was satisfied that the ultimate home for Mrs. Ferrara was at all times subjectively in her mind, which of course is what's the key, England. The only other points to emphasise from those decisions are in relation to the burden of proof, which clearly lies on the person who is seeking to prove a change of residence, and also the need for there to be cogent evidence, which is a point that's made both in the decision in Barlow Close, but also in Kistramana. Well, before I turn to the judgment, can I just ask the court at this stage just to look at the way the case was placed before Mr. Justice Garrido. And so if we turn to the supplemental bundle and my note that was provided to the judge prior to the hearing, which you will find at page 196 in the supplemental bundle. you'll see at pages 196 to 197, we refer to the relevant principles.
Sorry, where is it?
Supplemental bundle, page 196.
Thank you.
So you'll see at that page and on subsequent pages the relevant principles that were placed before the judge, which he clearly must have had in mind. And we then go on from the bottom of page 197 to refer, as I said, to Udni and Udni, which refers to the need for the residents to be freely chosen rather than being forced upon somebody through circumstances or other reasons. Paragraph 46, we made the point, which again the judge clearly had in mind, as I'll demonstrate in a moment, that the issue of a person's or a spouse's domicile is a matter peculiar to that person, and it can differ from their other spouse's domicile as a result of the statutory change brought about by the Domicile and Matrimonial Proceedings Act in 1973. And you'll see also the reference to IRC and Bullock, which deals with the point of a domicile being retained even in circumstances where the plan to return to that country or the prospects of returning to that country have some degree of uncertainty about them, which is essentially the Kistramana point. So that, well, those are the principles that we say the judge clearly had before him because we put them before. Can I also ask you just to turn on then to page 200? And from the bottom of that page, paragraph 55, we set out Mrs. Ferrara's case as to the issue of whether she abandoned her English domicile or acquired a domicile of choice in Italy. I don't propose to read it out, but if you look through the paragraphs, and particularly subparagraphs, this is paragraph 55.
Thank you. Yes.
So it's moving on from the law, where we were setting out prior to the hearing precisely how we put Mrs. Ferrara's case in relation to the retention or loss of her domicile of choice in England. You will see how it was put there. I particularly draw your attention to subparagraphs 2, 3, 4, and 6, where we were very clearly making reference to what was obviously the correct legal test, which is what were her intentions, her subjective intentions. We did not put the case, contrary to what Mr. Marshall suggested this morning, on the basis of there being a mutual intention to return. I respectfully agree and submit to the court they are correct. The observations made by Lord Justice Miles this morning in relation to the passages that you were taken to in her statement, particularly her first statement, relating to an understanding as to that she may have had as to Mr. Ferrara's intentions. It is perfectly possible for her to have an understanding which is incorrect, but it was certainly never her case that there was an express agreement or a common understanding in that way. And of course, it is in no way a requirement of a finding of her domicile that she shares the same intention as her husband. As we know, as a matter of law, she is perfectly entitled to have her own different domicile and her own different intentions. Well, if I may now turn back to Mr. Justice Garrido's judgment. So we return to the core bundle, and your lordships have already been through this yourselves, and again with Mr. Marshall, so I don't seek to spend too long on it. But we see paragraphs 11 and 12, the very important findings the judge made as to the credibility of the witnesses. And those are conclusions which in my submission it is not open to this court to interfere. We then have paragraph 15. His comments adopting what was urged upon him by Mr. Marshall at the hearing, and of course I also agreed with it, that this is not an exercise that requires a weighing of every evidential grain of sand. And I make the point the judgment has to be seen in the light of the fact that the judge was not being encouraged to carry out a sift of every single piece of evidence, but only to deal with that which is, in his mind, most important, which is what he did in his judgment. We then have a paragraph 15, his identification of the test that he was applying, and you can see it in the fourth line, so the third line running to the fourth line, where he identifies that the domicile of choice in England arises by combination of a residence here and an intention to remain here permanently indefinitely. So he was clearly applying the correct test that he had taken from Barlow Close. Paragraph 16, and although it deals with the issue of the acquisition of her domicile, against which there is no appeal.
Sorry, can I just come back to the test that you say he applied? There was some debate this morning about the distinction between permanently
Yes.
and indefinitely. What's your submission on that? Because it might seem a bit strange to say permanently indefinitely for this reason. Obviously, if it's permanent, then it's indefinite.
Yes.
But if it's indefinite, it's not necessarily permanent, is it?
That's right. That must be right. Yes. My lord, it's why I made the comment I did earlier on and drew your attention to what was said in Barlow Close about the test being understood, and I'd say particularly helpfully in the context of a situation where somebody has left a jurisdiction with the intention to return. The test being put in those circumstances as being the jurisdiction in which somebody would choose to end their days. Because that far more naturally fits those circumstances than circumstances when one is talking about living somewhere permanently when one is not living there at all. And of course, we know from all of the authorities that it is perfectly possible not to live in a country and yet retain the domicile in it. So the words are somewhat inapt in this context, although they are perfectly apt in the context of an acquisition of domicile, because one is then both residing in the country and having the intention to continue to do so permanently and indefinitely.
Well, yes, but if I may say, that's a very helpful point. But doesn't that tell us that what the judge is focusing on here is acquisition, which indeed is the natural reading of the sentence anyway, because in the third line he says she most certainly acquired a domicile of choice.
Well,
so in England, so he's looking here at acquisition. He's not looking at loss.
But we could see he clearly had before him Barlow Close making it clear that the test for a loss is the obverse of that. And we could see it applied through the words he then later uses when we look at paragraph 18, where
This is why I'm exploring the question, because I'm a little puzzled. I'm not saying this is your fault, and it's not necessarily a point against you, I don't know. But it seems to me you've helpfully pointed out that actually you can't simply apply the test in the same way in the two different contexts, and that seems to me to be perfectly logical. And yet you're making a submission, notwithstanding that, the judge was right to apply the same test in both contexts, and I'm just struggling to reconcile those two.
well, it's the test that the authority told him to apply as the words that he was applying. You see he's taken those words from Barlow Close. I make the wider point that in terms of what those terms mean, this court views it in that wider way that I expressed and adapts it to the circumstances where somebody is not actually living in that jurisdiction but is retaining the intention to do so into the long term in the future. But in answer to your lordship's point in terms of identifying that he addressed it, it really comes to its crux at paragraph 19.6, and I'll in a moment work through the path by which the judge gets there. But it's the finding that her intention as to residence in Italy was temporary. So it's a clear finding that he's addressed his mind to the question of whether she had changed her intention from that which had given her a domicile of choice in England, and concluding that she had not. But I've jumped to several stages in the submission I was going to make in answering that question. I will do so now and hopefully bring it together even more clearly by doing so. So, my Lord, I was making the point that paragraph 16, although it deals with the acquisition of the domicile of choice in England, is not forgotten when we move on to the process of examining the judge's conclusions as to whether that has changed, because that's the starting point. And so paragraph 16 is very important, and the findings that he makes there, which are not appealed, and there's no effort to go behind them by Mr. Marshall. The points that he makes at paragraph 1 about having her closest connections throughout her entire adult life, the language at 3 of being primarily anchored. Anchored is clearly a very strong term to use. We have at 16.4 references to her entire working career being based here, and I would suggest that when you see the judge use the word commitment within these paragraphs, he's clearly referring to her intention by the use of that term. In fact, he uses the word intention several times during the entire paragraph. And then we have at 16.8 over the page his conclusion that every aspect of Mrs. Ferrara's adult life has demonstrated a permanent commitment to living in England that is enhanced by her obvious reluctance to move to Italy in 2019. Now, although the judge has put that paragraph within the section where he's given his reasons for finding us to a domicile of choice in England prior to 2019, that point clearly carries over to the analysis of whether that was lost, because that's the starting point. And so we make the point that the judge had found not just that there was a domicile of choice in some way likely or recently adopted in England. He was making a very clear finding that there was a very firmly established domicile here. And for that we can read, the judge was also equally satisfied there was a very firm intention and commitment on Mrs. Ferrara's part to retain that, unless there was some compelling evidence otherwise. So we've already seen that at 18, he has considered separately the question of whether she lost it either in 2019 or, importantly, at any time since then. So he was addressing the test broadly across the entire span of time from 2019 until the relevant date when the divorce petition was issued in this country, which of course is the critical time. And we then have his reasons set out at paragraph 19.
Yeah, can I ask another question, pursuing the theme I was on earlier? Because we saw that in paragraph 50, he talks about permanently and indefinitely. In 19 sub 2, he says this is a world away from having a settled intention to live there permanently.
Yeah.
No reference to indefinite. What do you say about that?
Well, one has to read the whole of paragraph 19 together with the earlier reference that we've discussed. But it's clear when you read the entirety of paragraph 19 with the conclusion at the end that as far as the critical question as to whether she had changed or abandoned her intention to reside in England, he was not satisfied that she had.
That point I understand. The question I'm asking is a slightly different one. And let me put it in this way. is it your submission that even though he doesn't use the word indefinitely in paragraph 19, nevertheless that is the meaning it's intended to be conveyed?
Well, it must be. Given he's identified the test correctly as in permanently or indefinitely, it must be that he's referring to that same concept here. It would be a strange thing to.
Where did he say that's the test for loss? Because as we saw earlier, 15 is about acquisition, and there's no dispute about this. As you rightly point out, finding is not challenged as to acquisition. In that context, he says permanently, indefinitely, and in that context, well, maybe one could say indefinitely is surplusage. But when it comes to considering the question of loss, and what he's considering is the impact of not really the decision to move to Italy, but the fact that she stayed there for the length of time that she has, and he says, well, that doesn't show a settled intention to live there permanently. What about an intention to live there indefinitely?
Well, he deals with that, does he not, at paragraph 19.6, where he says the intention that he's finding is clear, the intention to do so from her residence in Italy. That is all the hallmarks in her mind of being temporary. We can see from that he was clearly finding that there was no intention for her to be in Italy permanently or indefinitely, but for a temporary period of
So
time.
you say that's tantamount to a finding of not indefinitely?
Yes, yes. Well, one has to look at it in the round, and one can see that he's satisfied that she is not planning to live in Italy permanently or indefinitely. He is also finding that she has a clear subjective intention of returning to England.
You've made a submission about context. I think the husband's case was that the move to Italy was permanent.
That was the way he presented his case.
That's
Yes.
his case.
Yes.
So I don't. I mean, it could be that in this, at the end of paragraph 2, the judge is addressing that case because it was in the husband's, I think, written evidence, oral evidence.
It was in his oral evidence. I was challenging cross-examination, but he stood by it.
And his submissions.
Yes.
That it was moved permanently to Italy.
Yes.
So in context, that was the case that was being advanced.
Yes, but essentially they're opposite sides of the same coin, to a large extent.
Thank you.
So, my lords, to run through paragraphs 19 again, not slavishly, because you've covered them already, but we see from the judge's comments there that paragraph 19.1, where he makes the point about a domicile of choice is not easily surrendered, residing somewhere else is not by itself sufficient, is again an acknowledgement that he's applying the test which looks beyond residence but looks at intention. Correctly, we submit with the authorities that he was bound by. We have in 19.2 his comments about the move being reluctant, and that is again an indication that he is accepting and applying the principles from Udny and Udny. We have at 3 his point about the retention of a home in London, which is again entirely consistent and powerful evidence of her intentions to return in the future. We have his point at 4 about, which again goes, I suppose, back to the Udny point about whether Mrs. Ferrara had an independent voice or was able to change her husband's wishes in terms of the physical move. But we also have the important concession, which was made in evidence and recorded here by the judge, that Mr. Ferrara accepted in evidence that his wife didn't want to move. His subparagraph 5 is clearly a reference to the domicile and matrimonial proceedings Act 1973, which he was referred to. And that again undermines the points that Mr. Marshall makes about the case being based in some way on common intention. It's clear the judge was focusing correctly on the issue of Mrs. Ferrara's personal subjective intention. And then we have at 6 what is clearly a reference to the point that we covered in submissions with him by citing IRC and Bullock, but which is now dealt with by the law as it's stated in Kist and Romana, which is fundamentally in our submission the same. Making it clear that she doesn't have to have a clear plan for the return. And then the ultimate conclusion, which is in our submission clear as to what his finding about intention was. We say that's clearly the judge being fully satisfied that her subjective intention remained. Bear in mind, that's where we're starting from. That she was going to live permanently and indefinitely in London, despite the move to Italy. And the reference to in her mind is clearly the judge's finding that he's satisfied that that was her bona fide and real intention.
Can you just help me on this question? And again, this is a point that puzzles me and may be entirely neutral, because it may be just one of those questions that actually, given the state of the law, doesn't arise. But am I right in understanding that it was not the husband's case that she'd acquired a domicile of choice in Italy on the assumption that she'd previously had a domicile of choice in England? I thought that was correct.
His case was that he effectively disputed any change of domicile from her domicile of origin. His primary case was she retained that, and he said it was Australia. He disputed her case that she'd acquired a domicile of choice in England before 2019. To be sure.
Yeah,
He said
those 2 points I've got, but what I'm trying to focus in on was what was his case about Italy?
his case in Italy was that she had acquired a domicile of choice in Italy.
Right, so
He ran an active case that she had.
that case was run on.
Yes. So when you read paragraph 19, you have to see that the judge is answering that case as well, but in the context of whether she had lost her English domicile by acquiring an Italian.
Well, that's why I'm asking the question, because on its face, that the judge doesn't seem to be addressing that case in paragraph 80, because we know that if you have a domicile of choice and you lose it without acquiring a new domicile of choice, then you revert to your domicile of origin.
Yes.
And hence the importance from the husband's perspective as it was presented at trial, as you just rightly pointed out, saying, well, the domicile of origin was Australia, and that was quite important. But what the judge is focusing on here, as one sees from paragraph 80, is the question of loss of domicile of choice. And of course, that's the question that
Well, the two questions
is all left for us. He's not addressing, is he, a case of she's acquired a domicile of choice?
Well, my lord, I would suggest he is, because he's addressed the question and made a finding that she had no permanent intention of living in Italy. And he's made a finding that she regarded her move there as temporary. That is, although he doesn't say so in terms, I accept that. But it's impossible to read those words without believing that he has had in his mind consideration of whether she had moved to Italy with an intention of remaining there permanently and indefinitely. And he was clearly not satisfied that she did move with that intention. So, my lord, I concede he hasn't addressed it in the explicit terms your lordship raises the question, but it's very clear that he's answered the question.
Thank you.
My lord, it doesn't of course end there, because although he then moves on to deal with the issue of appropriate forum, some of what he says, paragraph 23, and again I'll return to this on the topic of forum discreetly later in my submissions, but you see there further points that he makes in relation to forum, which of course will have informed his thinking on domicile as well, and which this court is perfectly entitled to adopt as additional reasons for his conclusion.
Sorry, can you run that one by me again, because I don't follow that at all. Your submission is that reasons given in the context of deciding what's the most appropriate forum are to be taken by us as being reasons for his decision on domicile.
My Lord, additional reasons. We've raised them by way of our respondent's notice.
Oh, in your
As it-
respondent's
yes.
notice, to be sure.
Yes, yes.
Oh,
So-
I see.
So there are additional reasons that buttress the decision he reached. He didn't specifically put them under that category, and I therefore see the difficulty in saying, yes, but they were clearly in his mind, and we put them in by way of respondent's notice. The court, in our submission, can factor them into the decision in either way, but either way, they assist in the conclusion. And the points are those that are at 23.4, which is about closest connections with England, not for a short period, but since 1992, representing most of Mr. Ferrara's working life. We have at 5 the fact that there are no assets in Italy and the connections with other jurisdictions, which again is a relevant piece of evidence for the issue of acquisition or change of domicile to Italy. We have at 6, in a similar point, the ownership of a property in London but no equivalent in Italy. And we have at 7 an important feature, which is Mrs. Ferrara's own working experience, being, again, use of that strong word, anchored in London. And it's where she has the best chance of remaining employment, which, again, is significant in terms of evidence which supports her subjective intention, being to return to England, which is what she asserts. So, my lords, moving on to specifically our respondent's notice and the points we made there. We really run through an analysis that this court can and should perform if it feels that there are gaps or deficiencies in the reasoning that require filling and can be filled from the other evidence. The first stage of the analysis is the starting point of the domicile of choice prior to the move to Italy. The second stage is to remember that the burden of proof of a change lies not on Mrs. Ferrara but on Mr. Ferrara. And then the third stage is to look at the other evidence that supports the judge's conclusions, or which would further provide a basis for them. Well, I've already made the point about the starting point being a very firmly established domicile of choice in England, and the authorities make it clear that it is no longer the case that a domicile of choice is regarded as being less tenacious or adhesive than a domicile of origin. And I accept what Mr. Marshall said earlier on, that it's always going to be a matter specific to each case as to how adhesive it is. But in my submission, a domicile which has lasted for the best part of 3 decades is clearly very adhesive and tenacious. And that, of course, is the unchallenged finding the judge made. So it all starts from that. And I ask the court to have, again, in mind what Lady Justice Arnold said in paragraph 94 of Barlow Close, that a allegation of a change of domicile is, in her words, a serious allegation because of the serious consequences, hence the requirement for cogent evidence to displace it. The burden, as I've said, falls and fell on Mr. Ferrara to establish that change. And the cases make it clear that's where the legal burden sits. But the additional point that I make is that that also creates a very heavy evidential burden in circumstances where the domicile of choice is as firmly established as Mrs. Ferrara's was in England up to 2019. So my lord, we move from that to consideration of some of the evidence which the judge had before, which provides the matrix for the decisions he reached. And I make essentially 5 points in relation to this. They are set out in more detail in paragraphs 58 to 84 of our skeleton argument. I'm not going to deal with all of the points that are there orally. But the first point is one which I suppose goes back to the point that I just made about evidential burden. Where one has so established a domicile of choice in England with the firm anchoring in that jurisdiction that the judge found existed for Mrs. Ferrara, there is a starting point that any court's going to regard as inherently unlikely, that that's going to be abandoned lightly without there being good reason to do so. And it is inherently unlikely that Mrs. Ferrara, having established such a firm bond and home in England, would abandon it to replace it with a domicile in a foreign country, being Italy, with which she has no real connections at all herself, beyond the fact that she's married to an Italian, and where she's never lived before, and whose language she doesn't speak. The second point is her own evidence, which ultimately the judge said he accepted. And you will find her written evidence on the points in her statements. You've already been referred to some of the earlier statements, but I would highlight the fact that the passages that Mr. Marshall referred you to this morning, when he was asked specifically where there were references to discussions between the parties and the references to understanding. The statement he referred you to then was her first statement in the proceedings for the purposes of applying for a legal services payment order. That wasn't her substantive statement on the issues of domicile and jurisdiction. The statement where she set out her evidence in full.
This leads to the relevance of that. I mean, it's still her evidence.
It is her evidence, but it was dealt with briefly as part of background. If you want to find the meat of her evidence, you go to the statement which was designed to give that. And that's the statement which is at pages 600, supplemental bundle 113 to page 123. And it's specifically paragraphs 8 to 47 of that. The paragraphs which I would say are particularly important.
Paragraphs.
So it starts at page 113.
Yes.
Paragraph 8. And it continues through to page 123, paragraph 1. Paragraph
I see.
47.
Right.
The paragraphs which your lordships may find particularly helpful are likely to be in my submission paragraphs 32 to 34. Indeed, we've looked already, I think, at paragraph 33 in the context of an exchange this morning between the bench and Mr. Marshall. But it's paragraphs 32 through to 34 that are significant because of the direct terms in which Mrs. Ferrara explained her intentions, her feelings, her state of mind around the time of the move from England to Italy. Those passages were not directly challenged during cross-examination, and it's clear from the judge's findings as to the veracity of witnesses that he must have accepted them. Just whilst we're on the page, I would also draw attention to the very first 2 lines at the top of the page in paragraph 31, which refer to her feelings about Milan. But they also shed some light on the state of the marriage, which is again a pertinent point that we'll return to in a moment. Well, just while we have this part of the statement open, can I also just, although it's on a slightly different point, but just through convenience, address you to, or refer you to page 122. and paragraphs 41 and 42, where Mrs. Ferrara refers to her visits to the UK post the move to Italy. And the reason I simply highlight those is that the judge makes a point of paragraph 20 of his judgment, referring to only one return to the United Kingdom from 2019 until these proceedings started. You'll see from those paragraphs that that is actually a mistake on his part, because her evidence was that she had visited more times than that, and that was not challenged. So that's my second point, which is her written evidence, which, as I say, was not challenged. We then have my third point.
Sorry,
which is,
can I just,
yes,
sorry, that was paragraph 42, did you say?
41 and 42. So she refers in paragraph 41 in the third line to her friend, and I last visited in August 2024, just before things became difficult with being embroiled in divorce litigation. But then you'll see in the third line of paragraph 42 references to visits to London on 3 different specific dates.
But those are after the application, the divorce petition.
That is true, yes.
And the point the judge made is that you didn't visit before the
Yes.
divorce petition.
My
you've
learned
got-
junior assists me by reminding me there's also one further reference that I need to take you to. There was a statement in response to Mr. Ferrara's statement. Both parties had leave to file a statement in response. My client's is at page 173. These are the relevant passages. And you'll see it at page 17.
No, paragraph
Paragraph
17.
17. It's not a major point, but I simply flag it to indicate that what the judge said at paragraph 20 was not entirely accurate. My lords, the third significant piece of evidence is the emails that were contemporaneous with the move, or just before the move. And those you will have in the supplemental bundle at pages 127 to 136. They are, as is often the case with emails.
Mr. Marshall said some of them. Is that inaccurate?
I think there may be one further email that was not included as an exhibit to the schedule, to the statement, which I think Mr. Marshall asked to be added and was added to the judge's bundle. So there was, I think, one additional email he correctly identifies that isn't in your bundle, but was before Mr. Justice Garrido.
That was in March, I think you
Yes.
said. Was that the one he was referring to?
That's the one he was referring to, yes. They're somewhat out of order because there's 2 threads of emails and inevitably they run in reverse order. So this thread begins with page 136, which is an email from Mrs. Ferrara to her mother on the 1st of February. And we're going to read it out, but you'll see the first paragraph deals with a sudden urgency in discussions and the need to move to Italy, which you see is very much initiated by the husband. I'll ask you to note the second line, or the first line of the third paragraph, and the reference, I'm really enjoying life in London at the moment. And so it goes on about her feelings about and commitments to London. And we have the second half of that third paragraph, which is a very long way away from showing any form of commitment to living in Milan. And you also there have her concern that she might get stuck there. I think that's the origin of the words that Mr. Justice Garrido used in his judgment. We then have a further part of the same thread. You have to go to page 130 to find that. which is her mother's response to that. Sorry, the response is to an email that starts at the bottom of page 130 and goes over to page 131, which is the email from my client, which is I think the same email. Then you've got her mother's response. I would ask you to note what her mother refers to in the first and second paragraphs, and particularly the second paragraph, retaining a property in London. The context of which is clearly one of there being an understanding between mother and daughter that the connections to London are very strong. And we have the reply from Mrs. Ferrara to her mother at page 129. And her first paragraph, I don't know why it's in red, but the first paragraph is very clear. Third line, I don't want to move, I'm staying here. 3 lines from the bottom of that paragraph, I want them, this is referring to the children, to retain their English cultural roots and to be international. I'm not going to go through each of these exhaustively, but to refer you to the next one in the line is at page 127 to 128. I'll just highlight the following. Second line of the email at page 127. I haven't definitely committed to moving to Milan. There's then discussion about schools for the children in the next paragraph. At the end of that paragraph, you see her concern that Mr. Ferrara is just going to move and leave her and the children stuck in London. She doesn't want that to happen. She's going to move as a family, they're going to move. And in the paragraph that's in the second paragraph on page 128, her references to where she likes to live and referencing parts of London. And then a significant paragraph, penultimate one of the email, referring to the sale of the Belgravia property and her desire not to do so. We then go to page 135. We jump forward now to February, to later in February. And it's clear from the context of the emails that what's happened in the intervening period is there's been a visit to Milan by Mrs. Ferrara, so the discussions are slightly more focused. But you'll see on page 135 a message from her to her mother. Second and third paragraphs of that are, in my submission, significant in terms of her state of mind. On page 134, we have her mother's response. Second paragraph, her mother expressing concerns about how they will get on in Italy. And again, the importance of retaining a base in London, a property in London. Fourth paragraph, her advice about British passports for the children, which again is important, and I'll refer you to, in a moment, to some of the oral evidence that was given about that. And the final paragraph on that page, page 134, with her mother asking her to think about the consequences should anything happen in the future. What we then have is the long response from Mrs. Ferrara to her mother at the start of page 132. And I highlight the first line of the email, her feeling somewhat sad and confused. And reference then to the fifth paragraph down, where she refers to a conversation that she and Mr. Ferrara had the previous night. I'll ask you to read the remainder of the paragraphs on that page. And then over the page, particularly the second and third paragraphs on that page. There's this paragraph, 5 paragraphs up from the bottom of the page. I'm not looking forward to this evening when he gets home. which gives some indication of the dynamics of what's going on. But the most significant part of it is clearly what's at the bottom of page 132, which is the reference to the discussion about the potential for a divorce and moving wherever she wanted to. So also, those being emails, which I don't think anybody suggested were anything other than genuinely written at the time, giving an insight to her wishes and feelings at the time. They were not written with any eye to being scrutinised by a court years later in the context of a domicile dispute, are clearly significant. And they both evince a strong connection with London that Mrs. Ferrara wished to maintain. And they very strongly refute any suggestion that she was seeking to abandon her domicile in England. That was my third point, my Lord. My Lords, the fourth point is that the evidence that was in her witness statement was, by and large, not challenged in cross-examination. Relatively little of the cross-examination was specifically on the issue of domicile, and more specifically on the issue of her intentions. Certainly it was never put to her directly that she'd given up the intention of living in England. But if I refer you to passages which I think we've already flagged for you in our skeleton argument, but if we turn to the supplemental bundle and the transcript at page 286 of the supplemental. You'll see that it's not until page 36 of the cross-examination, that's probably not entirely fair, the first 4 or 5 pages of the transcripts are dealt with the opening, and then her evidence begins after that. But we are well into the cross-examination, having initially been dealing with issues that really relate to Fora, before questions start to be asked about the move and the circumstances around it. We see at page 286, just below B, and then for the rest of that page, the fact that there was an open discussion about other places that they may have moved to. Abu Dhabi, Luxembourg were both considered, and it was common ground between the parties that none of those were going to be permanent. And so that, again, fits with Mrs. Ferrara's understanding that Italy was not permanent. It was temporary for tax reasons. There's then questions that go on to a different topic, which is not in my submission related to domicile. They seem to be to do with how the Italian court will deal with the separation agreements and such issues. We return to the topic of domicile and intention on page 290. But they touch on the issue of domicile, but I think unintentionally on Mr. Marshall's part, because he's asking her questions about legal advice that she may have sought and when she sought it. But you'll see that she refers at the bottom of that page, just below G, to having had discussions with Mishka Derea in 2010, following Mr. Ferrara's affair.
What page?
This is page 290, which goes on over the page to her explaining the reason for that being because of marital difficulties. Two 298. From roughly C on that page through to the next page are a series of questions and answers in relation to British passports for the children. And again, although the questions touch on the process by which that was achieved, there is a important answer at page 299, right at the top of the page, where she's asked, why was it important for you to get passports for the boys, British passports? Because I wanted for us to be able to easily move back to the UK. And we see later on that page, page 299, from C below, a further exchange about her looking at obtaining a passport for herself too, British passport for herself too, in 2018, 2019. Moving on then to page 317. Is where there are questions that deal with her acquisition of domicile of choice in England from 1992 onwards. I don't want to spend any length of time on those, but that's where that was dealt with in her cross-examination. But we then come on to 319 at D, just above D, where there are the questions and answers that deal with what she had written in her original petition in England, the divorce petition, referring to habitual residence rather than domicile. And you can see how she dealt with that and the mistake, and this is where the judge indicated in his judgment that he accepted her innocent explanation in relation to that. That's what that reference relates to, not to the issue of who was involved in the sale of the property that Mr. Marshall suggested to you today. Three, two, one. Are the questions and answers about the sale of the London property. And you see those pages run on from 321 over to 323E. The theme of it being very clear that her evidence was Mr. Ferrara wanted to sell the property. She was not really on board with that, but felt she had no choice because the property was in his name. And as she says at paragraph 323, sorry, page 323 at E, he's not the kind of man you could argue with. And you'll know that's, the judge quotes that. He misquotes it slightly because I think he says disagree with, but it's clearly that passage that he refers to in the judgment. We then go to 326. G is a further answer in relation to the sale of the property and her references to being a dutiful wife, helping him out, but it clearly not being something she was enthusiastic about or indeed agreeable to. And then we have at 327 the passages where the emails between her and her mother, which we've referred to, were being put to her and questions being asked about those. And you'll see at page 328B the evidence she gave about her reaction to the idea of a move to Milan when Mr. Ferrara first suggested it to her. The word she used was horrified. As I said, there were no direct questions put to her in cross-examination directly about her long-term intentions by way of residence. In my submission, I think the height of it you'll find at page 331. The question that starts just above C.
Sorry, 3.
Sorry, 331. Sorry, did I say 321? I meant 331.
Sorry, starting where?
So it's the question that starts just above C. I'm not going over it all again, but that and the questions that follow, I think is as high as I see it ever being put to her directly. that there was an intention to settle permanently in Italy. And you see her answers. And then at 332, right at the end of her cross-examination, from C, or just about D below, are really telling answers from her. Referring to, I consider London as my home, been living here for pretty much all of my entire adult life, and so on. And then her answer at F, I was very worried that I would get stuck there, that I wouldn't be able to come back to London, which he did, which is what is happening right now. Now that's the evidence which the judge indicated he fully accepted from Mrs. Ferrara, and it's clear that that provides significant support for his findings. My fifth point is that Mr. Ferrara himself didn't give any direct evidence that contradicted Mrs. Ferrara's evidence. He spoke a lot about what his intentions were, which prior to the 1973 Act would of course been relevant because Mrs. Ferrara's domicile would have followed his while she was married to him. But of course the law's moved on from that, and Mrs. Ferrara is entitled to have her own intentions and her own domicile independently of that of her husband. You'll find in the transcript the relevant passages that I'll ask you to consider, starting at page 336F. Running on for the next 3 pages or so. Questions put to him about the reasons for the move, being primarily financial for tax purposes. You'll see at page 337 at C that he accepted that but for Brexit and tax issues, he was happy in London. The family were happy in London. At 337G, I put the question to him, it was not because your wife wanted to move, and he's clear, no. At 339A through to F, there's a series of questions and answers dealing about what might have happened if it had turned out after moving to Italy that his wife and his children hadn't settled and weren't happy there. And I asked him to countenance the situation that he might then have moved back. And you see, with his answer at E, although he didn't accept he would, he didn't either say he wouldn't, he said he'd look at it at the time. Can I now ask you to jump forward to 391? The whole of that page from B through to H are questions related to directly whether anything was discussed between them and what her intentions were. But you see within those answers and replies, he accepts that a move to Abu Dhabi or to Luxembourg would not have been a permanent move. And you can see the height of his evidence is really what he says in his final answer on that page. He accepts that she wasn't keen on living in London, probably. But he says, she never told me she didn't want to live in Italy forever. He does suggest she might want to go to live in Australia, which is not something that she accepted in her evidence. But he says she didn't tell me she didn't want to move to Italy. And then I proceeded to ask questions from C onwards on page 392 that really go to the issue of contingencies, circumstances under which she may well have returned to England. And obviously death in terms of him predeceasing her, which statistically accepted was likely because he was significantly older than her, was one eventuality. And then over the page at 393, similarly an acceptance on his part that a divorce, which is in fact what of course has happened, would also have potentially led to the same situation before returning to England. Well then, almost lastly, I think with the evidence, page 372.
372.
372, yes. So this is again in the context of asking questions about her state of mind. And I put questions to him based on some of those emails between her and her mother, contemporaneous with the move. And was asking him questions about what he understood her state of mind to be. And you see Mr. Marshall properly took exception to the way I phrased the question in the first place. But you'll then see I did encourage him to provide us with any evidence that he had as to what he believed her state of mind at that stage was. And you can see his answer is uncategorical at G. He didn't want to give any evidence about it. He didn't know what it was. You can see it continues over the page 373, where the learned judge himself similarly asked questions as to whether there were any discussions about this, and it's clear that there were not. And that continues over the page. And on, indeed, until we get to page 375.
So in the middle of, so you asked, it's not your case, he was saying she intended to permanently to live in Italy. And he says, how can I speculate?
Yes. It's very clear. I asked him a number of questions that if he had positive evidence to give, that there was some other intention on her part. And he was very specific that he wasn't saying anything either way on it. He was saying, I didn't know. And indeed, that is no doubt the basis for the judge's comment in his judgment, that he, during his assessment of Mr. Ferrara as a witness, that he was far more attuned to his own feelings than he was to his wife's, and to his wife's intentions or wishes, the state of mind.
Sorry, you were taking us to another page.
Yes, I was going to complete that exercise by so it points to where it concludes at page 375, where I think in fairness the transcriber has got this wrong, where he has attributed to Mr. Marshall two interactions with the judge there, which I think were not actually Mr. Marshall but me. So I think the transcriber's got the wrong speaker. But you can see I made it clear that it wasn't in my client's case that there were actually discussions between the parties on these issues directly, which is in line with her witness evidence. And I also made the point, again wrongly attributed to Mr. Marshall, that the dynamic of the relationship is such, or was such, that it's unlikely there would have been those sorts of discussions, which again is echoed in the judge's finding that he's not the sort of man you disagree with. So in a similar vein, my lords, just in the context of the emails, I think we've been close here already, but you'll see in relation to the emails, are further questions at page 388. Are specifically about the discussion about, or rather the report of Mrs. Ferrara saying there being a discussion between the two of them where divorce and the possibility that she could return with the children was discussed. He didn't. He said he didn't recall that discussion. He didn't deny it. He said he didn't recall it. and I'm already taking your lordships to his acceptance, when I put the question to him specifically, that he accepted, or at least didn't disagree with the proposition that if there was a divorce, Mrs. Ferrara was likely to want to not remain in Italy for any longer than she had to, but would want to return to England. So, my lord, you have a situation where the evidence from Mrs. Ferrara was clear as to what her wishes and feelings and intentions were, and that was not contradicted, in fact, by evidence from Mr. Ferrara. Well, the points that are made in terms of the appeal grounds in relation to the involvement with the sale of the property, discussions with the parties, the issue of the passport, in my submission we've dealt with in writing in our skeleton argument. I don't propose to deal with those any further unless your lordships have specific questions arising from any that it would be useful for me to answer. My closing submission in relation to the domicile issue is simply to make a reminder, which probably doesn't need to be made to this court, of the approach that the appellate court should take to a first instance judge who has made findings of fact, which he clearly has, as to Mrs. Ferrara's state of mind. And the well-known authorities, Fage, UK and Chobani, Volpe and others apply. And in my submission, there is no reason to interfere with the judge's central finding, which is that there was no sufficient evidence to displace the intention, or rather the domicile of choice in England continuing.
I think there are two elements. One is findings. One is what might be called an evaluative conclusion based on those findings as to where the domicile of choice was at the relevant time. Or domicile was.
Well, your lordship, of course, is right, and that's where ultimately the approach that I've indicated to the court is so important, because we start from a heavy presumption against a change of domicile, if you like, because of the heavily soundly established nature of the domicile of choice in England up to 2019, and then set against that where the burden of proof lies.
But I think an appellate court's approach to both findings and evaluative conclusions is the same. That so it applies to both.
Yes. Well, Lords, I've moved to forum and the judge's decision on that. Again, I don't think there was any dispute as to the law was to be applied at all, and of course it's well known, and the judge correctly identified the summary. I think as other judges have done, that His Honour Judge has usefully provided an essay in PA, which of course is largely a reference back to what the court had said in Spiliada and the principles from that.
Can I ask you a question about that?
Well, yes.
If we could look at the authorities bundle at that case, so that's in tab 7.
Yes.
And something that I would invite your submission on, because it may be there's a slight difference here between the usual approach of the courts in civil litigation and the test for family proceedings. And it says, if you look at page 165 of the bundle, the judge there explains that the power to stay derives from the Domicile and Matrimonial Proceedings Act 1973 and Schedule 1, paragraph 9. Now, is that the same jurisdiction that applies in this case?
According to what the House of Lords said in de Dampierre, yes.
Right.
Because they took that statute
Yeah.
and then said the Spiliada principle should be applied to it.
That's right. But if you look then at the terms of that statute, and in particular Schedule 1, paragraph 9,
Yes.
so in A and B, so that A is saying that the situation is where there are proceedings in respect of the marriage in question in another jurisdiction and here. So in other words, you've got concurrent proceedings.
Yes.
And then B, that the balance of fairness, including convenience, as between part of the marriage is such as appropriate for the proceedings in that jurisdiction to be disposed of before further steps taken in proceedings in the court, or in those proceedings so far as they consist of a particular kind of matrimonial proceedings. The court may order that the proceedings, that means the English proceedings, be stayed, or as the case may be, that those proceedings shall be stayed so far as they consist of proceedings of that kind. And as you say, in de Dompierre, the House of Lords said that the principles in Spiliaris, etc., are to be applied. But my question is this: in most civil litigation where this arises, what happens is the court, as Lord Justice Arnold said earlier on, simply stays the whole case. It says, we're not going to hear this case because there's another forum which is more appropriate. And the case, for all intents and purposes, comes to an end. This section seems to be more nuanced than that, because it seems to be saying that if there are concurrent divorce or matrimonial proceedings, this court may decide to stay some part of the proceedings pending the resolution of the matter in the foreign court. And indeed, arguably, that's what happened in the order that the judge made in this case. He didn't actually stay them with him. Paragraph 3 of his order, on page 63 of the core bundle, he left open, I put it this way round, he left open the possibility, as I understand it, of a more limited stay of part of the English proceedings pending the determination of certain parts of the proceedings in Italy. He didn't order that, but he said it was without prejudice to that possibility.
That was because Mr. Marshall reserved his position
Right.
to seek a stay of just the financial remedy proceedings.
Right. So that seems to be based on the idea that the English court could stay part of the proceedings, but not all of them. Now, do you wish to make a submission about that?
Because the matter's not been fully argued or even, I don't think the applications have even been made on the husband's part to do that yet. And my understanding of the basis of the application was going to be as essentially a case management stay that was being sought rather than a statutory stay under the 1973 Act. So,
Well, is that right, or were they seeking a stay under this Act?
well, as I say, the application has not been fully articulated.
No, sorry,
my
not the
understanding was that it was
one that's referred to in the order, but the one that was before the judge in this.
this was a stay of the matrimonial proceedings in terms of the application for a divorce order. That is
And is it
specifically what
were
was
they
being-
seeking a stay of the whole case?
Well, the effect of it would have been that would have been the same, because with a stay on those proceedings, the court could not have proceeded to decree nisi. And decree nisi is the minimum requirement before the court can make financial orders beyond interim financial orders. So the effect would be by staying the matrimonial proceedings, it would de facto stay the financial proceedings too.
Sorry. Can you explain this a bit? I thought you could get ancillary relief before a decree.
In terms of interim orders, yes. One can receive after a decree nisi or an interim order, the court can make an order. The order is only effective upon decree absolute. So if the matrimonial proceedings stop, so one can't proceed to those stages. And in this case, it would mean, because we don't even have an interim order, we wouldn't even get to the first stage where a court would be in a position to make a full determination, unless it adopts an unusual procedure, such as in the McCartney case. But that's normally only a situation where proceedings are ongoing and it's just a matter of administrative delay before the interim order or the decree nisi is made.
I suppose the purpose of my question was to ask this: is there in fact a way of saying parts of the proceedings might be stayed because, for example, the proceedings concerning the children have to take place in Italy as common ground. The proceedings about what should happen to the matrimonial home, who should stay in it, and so forth, are all for the Italian courts. But then it might be other parts of the proceedings which on that basis would not be stayed. In other words, is that something that can be done under this provision?
Well, this provision, my reading and understanding of it, is specifically designed to deal with the matrimonial application itself, which is the order for the status order, the divorce order. And certainly that's the way it was being used in these proceedings. What the husband was seeking was a stay on the matrimonial application for a divorce order.
But just to explore this question a little further, I mean, you can have this kind of outcome in civil proceedings because just as the analysis on jurisdiction must be a claim by claim analysis, so too, when you get to forum, it's a claim by claim analysis as to forum. And so you can have a situation where, for example, a claim is made in deceit, which the court would accept jurisdiction of, but it doesn't accept jurisdiction against, in respect of, say, a contract claim.
Yes.
Where there's an exclusive jurisdiction clause in favour of another jurisdiction.
Yes.
And the consequence of that can be parallel litigation, which is inherently undesirable. But that's just how the rules has to work. So you can have parallel proceedings, even in the context of ordinary civil litigation, being the ultimate outcome. But to get to the point that I'm interested in, presumably you would accept that any forum analysis, the court's objective will be to ensure, so far as is possible, that all connected proceedings between the same parties are dealt with in one jurisdiction rather than two or more, if that is possible.
Yes. Yes. Subject, obviously, to that jurisdiction being the correct one and the overall balance of convenience making that correct.
Sometimes it's
So,
not
but
possible.
it likewise, there will be cases where there will be some parts of the proceedings that are dealt with in one jurisdiction and others in other. Indeed, we referred, Mr. Justice Garrido, indeed we referred to it in our skeleton argument, to the case of J&U, which was the first instance decision of what went to the Court of Appeal as Kelly and Piles. And the only issue that went to the Court of Appeal was the finding by Mr. Justice Cobb that the wife had domicile in England. He had also made a forum decision that England was the correct forum, notwithstanding the parties lived in Bosnia, I believe, and notwithstanding the fact that all the proceedings concerning the children would be dealt with in Bosnia. So that was a situation where the children's proceedings were going to be in Bosnia. The parties were living in Bosnia, but he took the view that the forum was correctly to be identified as England. That was not appealed, and the Court of Appeal didn't interfere with that, but it did overturn his decision on domicile, which was obviously fatal to the decision and the approach to the case more generally. So that, I think, is what the judge had in mind at the end of his analysis of the forum factors, where he identifies specifically that there is no particular difficulty with a court in Italy dealing with certain issues and an English court dealing with other issues. And there are certain issues that he's identified that this court can deal with.
Because everything in this jurisdiction depends on the divorce proceedings.
Yes. Yes.
And I can see in different circumstances, because there would be different grounds for jurisdiction, that you could stay divorce proceedings, but the court would continue to have jurisdiction to deal with children, as Italy would in this case.
Yes.
It might be the opposite.
Yes. Yes.
So that but I don't see that you could. The effect, as you say, of staying the divorce proceedings is the financial proceedings that come to an end.
Yes. We no longer call them ancillary, but they are in the statute called ancillary relief because they're ancillary to the divorce decree. And without the divorce decree, there can't be the orders. And of course, to take my Lord Justice Arnold's analogy of civil litigation, yes, in a civil case there may be different causes of action with different jurisdictional hurdles to be crossed in relation to each and a different decision being reached, but there are not discrete causes of action within a financial remedies application. The court is being asked to exercise its discretion across the board, and one doesn't hive off lump sum orders from property adjustment orders or from pension orders.
While we're in this authority, can I have a question about paragraph 20?
Yeah.
paragraph 20 is when his honour Judge Hess says that the following principles emerge. That is his summary.
It's his summary of those authorities.
Yeah. And what he says in paragraph 1 is fairness and convenience depends on the facts of each case and all the circumstances have to be considered. The court should take a broad view of all the facts and circumstances, not just those directly relating to the litigation. And then in paragraph 2, the court will consider what is the natural forum, that is the forum with which the parties have the most real and substantial connection. Now, was that put forward to the judge as an accurate summary of the law?
My lord, nobody directly argued against this. If I recall correctly, I think this authority was cited by Mr. Marshall, and I cited directly Spiliada. So my references and arguments of the judge were based specifically on what was said in Spiliada and Dampier. Mr. Marshall relied on this summary, and the judge indicated that he was relying on this summary. No submissions were made to the judge by either of us on the basis that there was any distinction between them.
Because I think some analysis might be required of the facts and circumstances not directly relating, I suppose it depends on what you mean by directly relating to the litigation, but perhaps also the reference to the forum with which the parties have the most real and substantial connection. Depends on what he means by that.
In my submission, the correct way to read that would be the parties and the issues between them, and the litigation between them. Because it can't simply be that, because one is looking at the issue of which is the most convenient forum for the proceedings.
For the resolution of the
So parties must be a shorthand for them compendiously with the issues that they are engaged in litigating.
And this is always a bit odd because in the Spiliada line of jurisprudence, the first step in the analysis is always what is the dispute correctly characterised. And normally that involves looking at what the claim is, what the potential defences are. And then you move on from there, once you've analysed what the dispute is, to see which is the forum in which that dispute should be tried. Would you agree that that's the correct way to do it?
My lord, yes, save for the fact that in matrimonial litigation at this stage of a process, often precisely what those issues are is less clear because there's no formal basis of pleading. One doesn't set one's case out. At the beginning of the case, one simply makes an application for the court to consider the financial relief claims. Bringing it to the specific facts of this case, its relevance is on issues that the court was aware of were likely to arise in the proceedings. And two of those were identified this morning, and they're interrelated. There's the issue of sharing of the matrimonial assets and the interplay between that principle and the way that the matrimonial agreement, the Italian matrimonial agreement, would be viewed by a court in Italy, must be viewed by a court in Italy, compared to the way it would be viewed by a court in England. There are ancillary issues such as the process of disclosure and how that's to be achieved.
Well, help me on that, because normally that's regarded in civil litigation as being purely procedural, so therefore it wouldn't enter into your characterisation of the dispute. There's been some debate in past cases, what has ever pointed out, is about the extent to which differences in disclosure between different jurisdictions is a legitimate juridical advantage, and that's been established not to be relevant. So I don't see how disclosure gets into the characterisation of the dispute.
Given that in most financial remedies cases, the vast majority of the costs and the time and the effort in the case is spent on the disclosure exercise, it is the most fundamental part of the entire litigation process.
Well, that's true in civil litigation as well.
No doubt it is, but it is particularly heavy and often the focus in heavily contested proceedings of almost all of the cases in relation to disclosure, particularly when it touches on issues such as trust interests that are in overseas entities and so on. The relevance of it, again, in this case, and we'll see it in one of the judge's factors, is if there are assets in, for example, in Jersey, the issue of disclosure and the way a court would deal with it here versus a court in Italy would be highly significant, particularly because of the nature of the relationship between the English High Court and the Jersey Royal Court being one of much closer comity and cooperation than is likely to be the case with a court in Italy. So issues such as that are pertinent to the question of forum very, very centrally.
Well, they may be, but that would surely be at a subsequent stage of the analysis. And that comes into the question of, once you've dealt with, first you characterise the dispute, and you say where are the parties, then you say where are the witnesses, then you say where are the documents. And if questions are going to arise as to disclosure, well, that may be perhaps askable. How is that material to the question? Because if you're relying upon that and not as a juridical advantage, and you can't, then some kind of question about the respective powers of the courts, I don't know. But, I mean, how does that help us in this case?
Well, the cases tell us it's a broad evaluative exercise that takes into account all of those factors, and the judge has to balance them. So it helps us to the extent that the pool of factors is large, and the judge must make a determination as to which ones are more relevant than others and carry more weight than others, and exercises discretion on the basis of that. That's the approach that Spiliotto in the commercial context, but then de Dampierre by analogy in the matrimonial context applies. The way it applies in a family case will be specific to the issues that arise in family cases, in the same way as the way it arises in any particular branch of civil litigation will be specific to the nature of the issues that apply in that litigation.
Yes.
Well, let's now return to the judgment that I was going to now address. So going back to the core bundle,
Yes.
and paragraphs 20, well, it starts at 22 rather than at 23, which is where the focus of my learned friend's submissions this morning were. In fact, it starts at 21 because that's where he identifies that's the issue he's moving on to. But you'll see at paragraph 22, he correctly identifies the test in line with Spiliotto, which is not just that Mr. Ferrara in the first instance has to satisfy him that there is a more appropriate forum in Italy, but it's clearly the most appropriate, that being clear from the judgment of Lord Gough in Spiliotto as being the test. And then we go through his list of factors. My Lords 1 and 2 essentially go together because he's drawing a comparison between what proceeds in Italy, if the case is run there, and what proceeds here. Now, there's an important point to emphasise at this stage, which I don't think this morning's exchanges between yourselves, your lordships, and Mr. Marshall properly gave regard to, and that is that there is a duality in the proceedings in Italy which doesn't exist here. In Italy, there is first a stage of applying for an order of judicial separation. Only once that has been achieved does the court go on to deal with the divorce. Now, it used to be, and this was referenced in the Italian schedule, it used to be that those two processes were entirely sequential. One couldn't apply for divorce until one has concluded the process of the separation. There was a reform which is referred to in the schedule of Italian evidence as called the Cartabia reform, which now allows somebody to issue simultaneously an application for separation and for divorce. But what the evidence from the Italian lawyers did agree on, and you'll see this at page 73, is that when the court comes to deal with the matters, although the divorce application, so to speak, is sitting on the file, using my words rather than their words. It is the separation that has to be proceeded with first, before the court starts to consider the issues of the divorce. So this morning's exchanges in relation to the various applications that are currently proceeding in Italy, they are proceeding specifically within the context of the separation stage, because the court has not yet reached the stage of making a final separation order, and therefore being able to proceed to the divorce stage. The lease pendants application that's been made by my client applies only to the divorce, because there are no equivalent separation proceedings in this country. In this country, we go straight to divorce. So there can't be a lease pendant on the separation stage because there are no equivalent proceedings elsewhere. So the court in Italy will continue to deal with the separation stage, but it will then have to move on to making final orders and determining the divorce stage. And that's the issue, really, which is where the disputed jurisdiction between the court there and the court here applies. In my submission, that's an important distinction to make, and it also then puts into context what the judge was referring to in paragraphs 1 and 2 when he refers to the Italian court not yet substantively dealing with the parties' divorce. And that's why he makes the distinction with the English court being immediately able to bypass stage 1 and go straight into the divorce without going through the preliminary stage of the separation.
Maybe I'm missing something. In civil proceedings, if the evidence is that the English court will decide in 1 year, but the foreign court will decide in 2 years, that's not a factor favouring England as a forum. It's simply a consequence of which forum you end up in.
Well, my submission, it should be a factor in circumstances such as this in a family case that one considers the speed with which proceedings will proceed to a conclusion.
So your submission is that in family proceedings, the natural forum is always the quickest one. Can that really be right?
My lord, it is a factor in determining what the natural forum is. It's not an automatic, because proceedings are quicker in one jurisdiction than the other, that means that is the forum. But it is a factor that goes into the balance to indicate that that may be the appropriate forum. And it goes into the balance with all of the other factors. If at the end of the balancing exercise, the balance is in favour of the English forum, that's where it goes, or vice versa. If it's clearly in favour of the other, and of course it has to be clearly. And my lord, routinely in the authorities, the issue of speed and delay in the family cases is taken into account and is in my submission, a proper factor. My lord, paragraph 3 deals with the issues of language. There's obviously no challenge to the factual statement there, and it is clearly a significant feature, but it was obvious before the judge himself that Mr. Ferrara gave evidence in English without an interpreter, without difficulty. That is not something which will be mirrored in Italy. My lord, for the most pertinent part is the second sentence that deals with the ongoing connections with England in terms of the business, still having substantial connections here. And that justifies the English court looking at the fact that the asset to some extent is based here. That also touches on the issue of disclosure in due course. By contrast to that, 5, there are no...
How does the fact that the business has an office in London mean that there's an asset of even of the business, let alone Mr. Ferrara?
My lord, it may be that the equitable interest and the beneficial ownership is held somewhere else. But certainly when it comes to issues of...
Sorry, it could be a rental. Why is there an asset?
Well, my lord, the ultimate owner of the business, I don't think Mr. Ferrara disputes, is him, via a line of companies that are in Luxembourg. But that doesn't change the fact that ultimately, if there's value here and he's the ultimate owner, there is an asset of his that's here.
judge doesn't seem to be talking here about the presence of assets. Assets he deals with in subparagraph 5.
Well, in my submission, I think 4 and 5 need to be read together in that sense, as being a comparison. Because in 4, he's looking at the fact that there are assets
So
with
can
an
I
English
get-
connection,
can I
and in
get
5, he's
this
making the
straight?
comparison.
Because I confess I hadn't read little paragraph 4 in this way, and I now need to reread it in a completely different way. So your submission is that when the judge says that Mr. Ferrara's business still has an office in London, we understand that to be a finding that there is an asset in London which could be the subject of a financial remedy.
Yes. And even if your lordships are not with me to that extent, it also highlights the fact that there is a business entity here, which the disclosure relating to which is going to be pertinent to the financial remedies. By contrast, there are no similar assets in Italy. Now, when it comes to obtaining disclosure
I'm sorry,
in
I don't
relation to
understand.
assets.
I thought it was common ground that business had moved operations to Italy.
No, it wasn't. No, there was no evidence that it had moved to Italy. Mr. Ferrara's evidence was that the economic base of the entity was in Luxembourg, not Italy. The only assets.
Sorry, sorry, I apologise. I misphrased my question. Absolutely, his evidence is the assets are controlled through Luxembourg anyway.
Yes. The majority of his savings, he also said, were in
But
Luxembourg.
the office is in Italy, isn't it? But I misunderstood.
He has an office in Milan, as I understand it. That was his evidence. He has an office in London. And as far as I know, an address in Luxembourg, whether it's an office or not, we don't know.
So the judge's finding was that he wasn't persuaded the business had lost its substantial connections with England.
Yes. But at the very least, that is a factor in the discretionary exercise, because if there is an entity here which is amenable to English courts' disclosure orders, or with third-party disclosure orders, that is a significant difference between, and a significant advantage, that there is to having proceedings dealt with here, rather than in Italy, where there are no substantive assets at all.
Yes.
Paragraph 6, I can see is a reference to a matter which is retrospective, looking in terms of what was here by way of connections. And I can see that the extent to which the judge has brought that into the equation is difficult to see the relevance of. His point at 7 about working experience is relevant because one of the issues a court will have to deal with, or may have to deal with in financial remedy proceedings, is assessment of her future earning potential.
I'm sorry, but what's that got to do with 4? I mean, again, it's equally retrospective, isn't it?
Well, my lord, that one is not merely retrospective because he's referring specifically to her future prospect of employment.
Could be one of the factual issues in
Yes.
the case.
Yes,
So it's relevant to the litigation.
yes. But then that one, although he refers to it as being historical in the sense that this is where it was, he also clearly refers to the future in terms of the chance of remaining employment. So it's relevant to the issue of future earning capacity and her employment.
And when you're looking at, as my lord raised earlier on, the issues in the case, and was looking at the financial remedy proceedings are quite broad.
Very good. But it's all the circumstances that may be relevant.
It's all the circumstances. I mean, for example, if one is looking at housing, we look at quality of housing, length of housing, and so on and so forth. So it includes analysis of the history of the case, the history of the marriage, and level of expenditure and
Yes.
so on.
And in the context of a situation where Mrs. Ferrara's case is going to be my long-term wishes to reside and work in London, it will be an assessment of what those costs and what those prospects are in London. And a judge in London is clearly far better placed to make those sort of decisions than a judge in Milan.
Well, that's an interesting point, but where does the judge say?
My lord, I am inferring from what the judge has said that that is the basis upon which he's put it in, and that's why I'm saying it is relevant. My lord, the reference to the language of the children, again, I concede it's difficult to see the relevance of that, given that it was common ground, that the proceedings in relation to the children are not going to take place in England, or at least not anticipated in the immediate future to be dealt with in England.
Yes.
So I'll just put it momentarily.
That was 8.
Yes, so that was 8, 9 and 11 in my submission need to be read again together to properly understand their effect. The issue in relation to the Part 3 claim is largely the one I think that was identified this morning, which is that although, yes, there would be a fallback Part 3 claim even if proceedings took place in Italy, the judge was taking the view, correctly in our submission, that it's futile to go through a process in Italy that deals with the finances, when it's very obvious that because of the matrimonial agreement, there will be a further claim in this country under Part 3. So he was taking the view, and you can see it very clearly if you read 9 and 11 together, that this court here would deal with the agreement in a different way to the Italian court, which is a juridical advantage which is relevant, that by itself, as you correctly states, wouldn't be enough, but it goes into the balance as a factor with other factors in favour of England.
Right,
So
so,
there's
so as I understand it, this is a submission that when the judge says proceedings in Italy may well not prevent a future claim, what the judge meant was proceedings in Italy definitely won't present a future claim.
Well, when you read that
because
with
it's
11,
inevitable.
when you read it with 11, it makes it very clear, and as my Lord Justice Moylan pointed out this morning, the basis of what's said at 11 in terms of the difference between the way the Italian court and the English court will deal with that agreement means that a Part 3 claim has real legs and is inevitable rather than simply something which may occur. And my Lord, 10 likewise is a advantage in terms
But
of
in fairness
funding.
to the judge, or just on that point, he wasn't really being asked whether a Part 3 claim would be brought because he decided not to stay the proceedings, so it's unnecessary.
No, but the argument that was made to him, and you'll see it in our, in due course I'll refer you to our submissions that were made on the issue of forum more broadly. The point that was made to him was exactly the point that I just made, which is there will be a Part 3 claim if you don't get on with the case here, so just get on with it. And that, together with many of these points, they tend to mesh together. So one takes one point and it overlays on one of the other points to make it a stronger point. So the issue over delay to the proceedings together with the duplication, together with the fact that there will be inevitably a further application, all tend to go together. And those in my submission are very strong factors which the judge correctly took into account. And so, my lords, even if you were to take the view that by saying what he did say in relation to the children's language, for example, and taking into account an irrelevant consideration, in my submission, if you justify that as being a reason why you need to review it, when you carry out the review and you look at the factors, those factors will still carry the day, and you'll come to the same conclusion, albeit for different reasons. My lord, then he deals with paragraph 24, the points that were made that didn't persuade.
Sorry, did you have a comment on 10?
Well, 10, yes, 10, I don't think, again, there was any factual dispute about. I know Mr. Marshall says, well, if essentially she could litigate on credit forever in Italy. but he makes that submission without any evidence. But there was no dispute of fact between the Italian lawyers that there is no equivalent to a legal services payment order provision in Italy. So where the court here, as it has done twice, it's made orders prior to the jurisdiction hearing to allow Mrs. Ferrara to be funded by way of a payment which was made by Mr. Ferrara. And again for this appeal, after Lord Justice Cobb gave permission to appeal, he granted a stay to Mrs. Ferrara to enable her to make an application which was dealt with by Mr. Justice Peel, making a further payment that's allowed her to be represented here today. But for that, she wouldn't be represented here today. There is no equivalent in Italy beyond the fact that to this stage, her lawyer has extended credit. So there was no evidence before the court that that would continue indefinitely. What was clear is that there wouldn't be a similar provision that the court could mandate in Italy to that which it can here. My lord, the comment that the judge makes at 24, paragraph 24.1 refers to the evidence that was given for the first time when Mr. Ferrara gave oral evidence to suggest that he was going to withdraw the allegations of conduct and blame for the divorce in the Italian proceedings. And there was significant questioning about that, and the judge refers to the difficulty in pinning him down on that. I'm not going to take you to the pages now, but just for your note, if you wish to see them, you'll find them in the transcript of pages 352G and then 354 to 355 in the supplemental bundle. What is notable is that as yet, he has taken no steps in Italy to make good what he told the judge. He said he'd withdraw the application, or at least he said he'd consider withdrawing the applications. To date, he has not done so. And in my submission, the judge's conclusion that that was not enough is sufficient. And my learned friend has referred in his written argument, although not I think addressed to you orally today, to a decision in VS and KS by Mrs. Justice Arbuthnot, where she made an order for a similar blame provision to be removed from a Monegasque divorce petition on the husband's undertaking to do so. And she made a conditional stay of the English proceedings on the basis that he would do so. But what I would point out to your lordships, if you look at that judgment, which is in the bundle of authorities, tab 8, the difference between that case and this case is that in that case, that was the sole allegation of this nature, the sole juridical disadvantage that was going to be faced, which the court dealt with by way of that conditional stay. In this case, the judge correctly identified that as well as the fault which would have resulted in my client's claims being reduced yet further in Italy, he did also identify the juridical advantage in relation to the approaches to the separation, to the marital agreement, which is an additional factor which Mr. Ferrara was very clear about in his evidence. He stood by. And indeed, in answer to the admittedly rhetorical question from Lord Justice Moylan this morning as to whether the parties are considered divorce continuing to a divorce decree in Italy and then Part 3 proceedings here to follow, the reason it seems in this case why that hasn't even been discussed is because it's been very clear from Mr. Ferrara's evidence that he relies on the Italian agreement and only wishes the Italian court to deal with it for that reason. Well, Lords, there is a specific ground that was raised, and indeed it seemed to impress Lord Justice Cobb when he granted permission on this ground, but the judge didn't refer specifically to the Italian evidence, Italian legal evidence in his judgment. And it's right that he doesn't refer to it by name. But in my submission, and we've dealt with it in our notes, or our skeleton argument of paragraph 90, it's very clear where he refers to the passages that we've discussed this afternoon, that he's making reference to the Italian schedule, because that's the only source of information about the differences between Italian law and English law that there were. But he does very clearly address those. Had Lord Justice Cobb had the Italian law schedule, which I don't think he did within the permission bundle, he would have been able to see that cross-check. But instead he appears to have been impressed by the fact there wasn't reference to it, and therefore assumed the judge had neglected to pay attention to it. It is clear from his judgment that he didn't. He did give regard to it, he didn't ignore it.
Yes.
My lords, I think that the only last issue for me to address is the issue of disposal, which my Lord Rochester Moylan raised this morning.
Yes.
We agree that if there is to be if there's any merit in the appeal in relation to the domicile issue, it would need to be reheard. This court can't replace it, and we say, for the reasons that I indicated, there are ample reasons to agree that the judge's decision was correct. In relation to the forum, we acknowledge that this is a case where if the court feels that there were deficiencies in the approach by the judge taking into account factors that were irrelevant, this court is in a position to carry out that evaluative exercise. And we don't seek a rehearing of that. But we ask the court, if it does do that, to have regard to the totality of the arguments that we put before Mr. Justice Garrido. And you'll find those in our note, not our skeleton argument, but our note for the lower court. It's in the supplemental bundle at pages 205 to 208.
Yes.
And I would ask the court to bring those into account fully, although we say that largely the judge already has at least acknowledged them in his judgment, albeit briefly. My submission, my lords, if you do carry out that exercise, you will still reach the same conclusion for the reasons that I articulated this afternoon.
Thank you. I'm not sure we've been provided with cost schedules, have we?
Not that I've seen, no.
Well, yeah, of course, we will do that. Not.
Yes. Thank you very much. Yes, Mr. Marshall.
I will try to be as brief as I may, and in some respects I may just deal with specific points. My learned friend invited your attention to how his client's case was put before the judge in relation to intention, and he took your lordship to page 201, perhaps I can just...
201
of
of...
the supplemental one. Where...
Sorry, is this oral evidence?
No, it's my learned friend's note.
Oh, okay, thank you. Yes.
And in essence, he said, well, the wife was putting her case on the basis of subjective intention, not ever on the basis of mutual agreement or discussion and agreement that the move to Italy was temporary. And what one might ask rhetorically, well, how does that sit then with the evidence we looked at this morning? You've already got the references in the supplemental bundle. It's
in the witness statements?
Yes, it's 42, 40 and 43, paragraphs 6 and 10. This was the point about we had agreed effectively it was only going to be temporary for a couple of years or briefly. And my learned friend says, well, that was only her first witness statement. Could I ask your lordships to look at page 117 in the supplement?
So why were we looking at what 201?
Because my learned friend said his case was advanced on the basis of the wife's subjective intentions, not on the basis of any discussion or agreement or meeting of minds between the parties, which is what I took you to this morning. Does your lordship have 201?
Yes. Thank you.
You see, W understood the move was principally for tax reasons rather than the middle of 201.
Yep. Thank you.
And he said, well, the evidence, I think, my lord said, well, her earlier statements were evidence as well. If one looks, in fact, and we weren't taken to it, at page 117, please, in the supplemental bundle. Now, and this is the wife's substantive witness statement before the trial, before my learned friend's note was lodged with the judge. At paragraph 20, the wife says in turn...
page again.
I'm seriously, 117.
Thank you.
The wife said in terms, Ferruccio will say that we made a mutual decision to move to Milan on the understanding it was to be a permanent move. And then she talks about an imbalance of power within their marriage, which had continued. And then she says, Ferruccio will vigorously try to resist the truth of what was intended and agreed and understood between us prior to the move. So the wife wasn't backing off, as it were. That's an elegant phrase. The wife was not, as it were, changing her case, as my learned friend suggests in his note she had. She was confirming. And so the idea of subjective intention appears in my learned friend's note. He took us to that at 2:01. And your lordship asked, well, did the husband say that the move was permanent? Yes, he did. Because the wife was saying, no, we agreed it was temporary. It was brief, it was for a period of years. And so the case may have shifted when we got into court, but the evidence that stood behind it hadn't. At no point in her evidence, indeed at no point in the emails that their friend took you to, which of course are proximate to the material events, was the wife saying, well, it's only temporary. Your lordship's asked, are we only missing, or there was some suggestion we were only missing one email. I think in fact we're missing two, only for completeness. And the one that is principally missing, and I'll ensure it is sent to the court, is, as Lord Justice Miles said, there's one on the 3rd of March, and this is the one I refer to. Can I just read your lordship's now? You were taken to the 28th of February. A few days later, 3rd of March, from the wife, I'm feeling much better this weekend. I think because it's been decided that we are moving to Milan, then I feel less in conflict with my feelings. I have a clearer idea of where I'm heading. It's such a big change, but in a way, I guess, exciting. And then there's discussion about conversations they had over the weekend, and discussions they had about my client's health and mental health. And she says, I don't know how things will go once we're in Milan. Perhaps Ferry's work will go better if he's based in the city, where he has so many work contacts. At least I really hope so. And so it goes on. And the final email, 5th of March, is a response from the wife's mother. Yeah, I'm sure this is sent to you, is a positive, upbeat response from the mother, talking about how good it is the parties are communicating again, how the boys will probably settle into school, etc. The American school does sound rather good, and the type of school that should suit both of the boys. And at risk of repeating, that's the last email we had, a month before the move. There's nothing after that. Husband goes a month later, wife goes in August. And yet her witness statements, right up to and including March of 2025, are, we had agreed it was only temporary for a few years or briefly, and however much he protests otherwise, he knows what we had agreed. Well, that's a long distance, if I may say so, from the wife saying, my uncommunicated but strongly held intention was for it to be temporary and I was always going to come back here. Never said that to her mother. Can I, in no particular order, just deal with Melania Friend's point about whether the judge had in mind, that I appreciate the time, no, yes. I'll deal with it literally in seconds. Okay. That the parties can't get on with the divorce in Italy. They can in June, because on the 25th of June 2024, the allocated judge declared the parties' separation, and they have to be separated for a year, so they will be able to divorce in 2026. So,
Sorry, those dates don't make sense.
no, I know they don't. And I said
You
them,
said
and
20.
I was trying to hope nobody noticed. Which isn't it?
Oh,
You
I
meant
did.
25,
I meant 25.
and it'd be a year later 26.
Yes.
Yeah.
I meant 25. And so there's already a declaration of separation, and they will meet the 1 year requirement in June of 26. And your lordships discussed, and I don't need to say much about whether part of the proceedings can be separated off. I mean, the point I made this morning was about bifurcation. I think it used to be far more accepted, or at least possible, than it now is, where a court might say, well, we'll deal with the divorce here, but go and deal with your finances in the foreign court, assuming the foreign court has jurisdiction to deal with the finances without declaring a decree. Conversely, of course, if the divorce is not here, as another one said, the finances can't be dealt with, but then you go into Part 3 territory on the basis of the foreign divorce. And I don't accept that Mr. Justice Greeley was entitled to say, indeed, we had a very cautious discussion that a Part 3 application was inevitable, therefore we should just get on with it colloquially. Let's just have a substantive Matrimonial Causes Act financial remedies determination. Because, of course, the possible scenarios as to where the parties might be after the Italian court has dealt with custody, shared care, and permission to relocate with the children is, at that point, the wife may well have been resident in Italy for 7 or 8 years. I mean, one simply doesn't know at this stage if the wife is going to pursue her lis pendens and then an appeal before the substantive applications in relation to the children are determined. And it by no means follows, A, the wife could satisfy the jurisdictional criteria to bring a Part 3 claim, and or that the court would give her permission to do so, if at that point the parties were resident and had been resident in Italy, and the wife was going to remain in Italy. I mean, my learned friend says, oh, well, it was the wife's stated case that she was going to come back to England, and therefore issues, for example, of housing would have to be determined here. I understand all of that. But equally, the wife had to permit with the possibility that she, as I questioned her, may well remain living in Italy until the children have ceased their minority, which is potentially in another 10 years. And it's not at all, in my submission, a foregone conclusion that the wife would, as it were, be able to bring a claim, albeit it's a safety net. I appreciate it's a...
Well, it's predicated on the expert evidence from Italy saying no capital claims
Yeah, I understand.
whatsoever. And as I think I said this morning, that's quite a powerful platform. And when then you look at the other factors in Section 16 of the 1984 Act, connections and so on, they're quite strong, quite powerful. There are other quite powerful factors.
There are arguments both ways. I accept that. And that's begrudging concession on my part, and I apologise for it. But there are arguments both ways.
Okay.
But equally, the court would have to consider whether, if the parties have been effectively absent, living abroad for, say, 8 years, and intend to continue to do so, whether the English court is going to say, well, you were here for all those years before you left in 2019. We're going to give you permission. Let's get on with it. So it's not a foregone conclusion, but equally it is a safety net for the wife. And as the schedule makes plain, the court does in Italy does have scope to make provision, for example, for housing, just as we have here. I think we discussed that this morning. Only in relation to the husband's business and what the evidence was. I'm only going to give your lordships, if I may, 2-page references.
Yes.
It's in the supplemental bundle. The wife deals with it at page 48, and the husband at page 98.
Right.
And I mean, at the highest, in a sense, Mr. Justice Garrido says, I'm not persuaded it hasn't,
Right.
which is a slight begrudging rather than I find, as it were, that it does.
Okay.
Yes.
Running out of time.
I know, and I'm subject, if I may, just to checking if there's anything else. I don't think so, my Lord. I don't wish to make points that are only going to detain us and not persuade us.
Anything else? Anything else?
I'm so sorry.
And no, it's just anything arising out of that or not?
No.
Sure?
I think so.
Okay. Thank you all very much for your respective submissions. We will be reserving our judgments. They have provided you in draft for the usual very limited reasons, i.e. correct our grammar. And we would hope that once you proceed, we will be able to agree a draft order, but if not, we'll deal with any matters on paper. So thank you again.
All rise and please.